Hey everybody, good morning. How are you guys doing? I'm doing good. So I wanted to go over something that was a statement that one of Carlee Russell's attorneys said to NBC News. So in that article that we went over yesterday, there was something that I found kind of interesting. I believe that the prosecutor tried to resolve this case without going further and offered Ms. Russell a plea bargain, but she was advised by her attorneys, according to this NBC News statement, not to take it. So I just going to read this one small piece. It's the NBC News article about Carlee from yesterday. It's titled Carlee Russell, Alabama woman who made up kidnapping, is found guilty and plans appeal. It's dated October 11th. So we went over this yesterday, so we're not going to go over the whole article. We're only going to hone in on this one paragraph. And the paragraph reads as follows. Well, we'll go over two paragraphs. Anthony, so they're referring to her attorney, Emory Anthony. Anthony said that jail time was being sought, which we totally disagree with, and that with the appeal, the case will start anew in circuit court, NBC affiliate WVTM of Birmingham reported. Anthony told NBC News later that Russell's legal team disagreed with the plea offer and appealed it to the circuit court. WVTM reported that the judge's decision was procedural because a verdict is necessary for an appeal that takes it to that state court. So we're done with that article. I'm just going to kind of summarize what is being said. So when Mrs. Russell went to her hearing, it was already known that she was going to appeal. There is no evidence put on, there's no witnesses. The judge makes the decision on his own with the information that is known and provided to him. So at that time, it was already known that Carlee Russell was going to appeal the judge's guilty verdict. She was offered by the prosecutor, which I feel is so generous in this case. Very generous. Hey, let's wrap this thing up. Let's not waste any more time. We already know that this was not a real abduction, that there was not a real toddler. This is what you have provided in your written statement through your attorneys. So let's wrap this up. Let's be done with you, done with this. Here is a plea bargain. If you agree, you will plead guilty to these two charges and you will do 6 months each of jail time. Now, do we really believe she would have done 6 months each of jail time? No. We're not going to rehash that. Talked about that yesterday in the video yesterday. So let's move forward. The important thing is let's talk about plea bargains, right? Why do we have them? How long have they been around? How common are they? Now, I don't know if people really realize or not, but plea bargains have been around for a long time. The majority of cases, and I actually learned this when I was in college, so you're looking back many years ago, that the majority of cases are resolved through the plea bargain process. So this is the prosecutor. He's going to come to a defendant, make some kind of negotiative deal where a couple of things happen. Either they're seeking a lesser charge, a lighter sentence, or they may, there's a third thing. Let me just give you the definition, okay? And then we'll flush it all out. It's an arrangement in which a prosecutor agrees to press the less serious charge, drop some charges, or recommend a less severe sentence if the defendant agrees to plead guilty. So the third one was dropping a charge. So you can charge someone, say, with 5 different crimes. But if you do a plea bargain, you may only proceed with 2, 3, whatever is agreed and negotiated. Also, these are typically less serious charges. So you may have a situation where they're charged with a higher level, say first degree murder, but they may plead guilty in the plea bargain to second degree murder. And again, you may have 5 charges where you're dropping 2 and you're moving forward on 3, for example. And then, of course, the last one is you want a lower sentence. So you may agree that, okay, say if there's a sentencing guideline where the person can be sentenced from 3 to 5 years, the prosecutor may recommend the lower 4 years or 3 years or whatever they agree to, right? So let's get that piece out of the way because I want to hit on a few things and then I have just one article to go over and review, and then we'll wrap this up for today. Um, so I already said that there's really a high rate of plea bargains. It's like 98%. So the majority of cases they are plea bargained out. So this reduces the caseload going to trial. All of the work behind preparation for trial, discovery, putting on witnesses, having to do all of that behind the scenes work, especially if a case is very clear that the person did it. For example, you may have something like them on video. You may have very strong witnesses that are willing to come to court and testify because that's kind of a challenge, right? Sometimes you have victims and you have witnesses that do not want to be involved in the court procedure, the court process, going to court, or testifying. So that may also be a consideration for the prosecutor if your witnesses don't want to testify, if you can't find your witnesses, if your witnesses have passed on, um, if the witnesses are hostile, you don't want to put them on the stand. So you may consider a plea bargain. Again, if we had 100 cases, 98 of them will go through the plea bargain process and only 2 will actually go to trial. So just think that is a very high number. So behind the scenes, there are a lot of deals being made. This is a common practice, right? Where most people are not saying, I want to go to trial. So what would make Miss Russell want to go to trial? Sit in front of a jury and go and say, I am not guilty. Although we know in her written statement that she said that she lied, right? She said that these things that I had said initially are not true. I apologize. I'm sorry. I think she thought maybe, okay, if I apologize, maybe everything will go away. The legal process will just go away. The police wanted to interview me, talk to me, have me flush out more of my story, provide more specific details, kind of explain why I did this, why I said these things, why I went to the hospital, why I pretended to do all of this. I don't know how she's going to explain most of what happened away or in a satisfactory way that those 2 very low charges would rise to the level where someone said, no, you're not guilty. I don't think so, but I guess she's really not wanting to do the jail time. They disagreed with jail time, so they're pulling it, and that's her legal right. So whatever. Um, so a lot of cases they do not see the courtroom. They do not go to trial. They are resolved, concluded through this plea bargaining process. Now, some would say there's a benefit to the defendant, right? He may possibly get those charges dropped. He may get them reduced. He may get a lower sentence. Well, there's also a great benefit to the prosecutor too, right? Let's consider, what if your case is not as strong? What if you can't get good quality video footage? What if a witness passes away? What if a witness disappears? They don't want to testify or they move or you lose contact. That may be an issue with your case. What if your evidence is not as strong as you thought it was, right? And that's something else to consider. What if you feel that if you go to trial, maybe the jury would not have enough evidence. Sometimes it's not sufficient evidence, adequate evidence, enough to prove beyond a reasonable doubt that this crime happened and this is the perpetrator, right? You can face so many issues. You may have other cases that you're resolving and focusing on, and that this case, it may even be a small petty crime. something like shoplifting or um, retail fraud, something that is not to the level of really trying to seek justice. You may just want to get um, some restitution, repayment for whatever the theft was, for example. You're not really trying to get justice for a family because there may not be, it may be a victimless crime, it may not be a personal crime, it could be property, something like that. So the plea bargaining process is like a really big part and tool for the prosecutor. So most cases do not have huge uh, legal issues. Most cases are pretty straightforward. For example, drunk driving cases. A lot of cities see a lot of DUIs, drunk driving cases. Um, it's pretty hard to fight, and the court is going to take that very serious because for years now, people have been having these accidents, causing a lot of property damage, and sometimes unaliving a person through their actions, through the process of not being responsible when drinking, and then getting in a car and trying to operate it under the influence. So those cases like that, there's really not a factual issue or legal issue. So those cases may go through the plea bargaining process. That's pretty common because there's a really high chance that you're going to be convicted. So what are you fighting? If you took a breathalyzer and you failed it, if you took a field sobriety test and you walked along the road and you were falling, or you were not able to walk or focus, or you just failed it. That could be on camera. Do you want to be further embarrassed? Do you want this information, these videos, shown in court? You don't want to maybe suffer that humiliation. And then there's always a process, if your driver's license is taken, if you have to put the machine in your car that takes that has you breathe in to make sure that you're not drunk. It's a very, very costly expense if you get that DUI charge. So you really don't want that. So a lot of people will go through and take a plea bargain rather than go to trial. Um, Sometimes you may have an instance where the case may be rushed and a person is arrested, and then the prosecutor may make a deal with that defendant. And then after time, something later could come forward, more evidence, new evidence, video, and sometimes the public feels that the plea bargain system that's happening behind the scene in most cases is really not bringing justice. That the use of the deal is not always the community's best interest, although it is a great way to resolve cases. The community's best interest is not at heart, and if something is revealed later that's really damaging, say, for example, I'll give you a very good, interesting case. Say you have a person that is abducted. When they're abducted, they're taken to a home. There are several people, several different actors involved in the abduction, and that person, the victim, is tortured. Now, when this case is presented to the prosecutor may immediately say, well, we have some evidence. We know that the abduction occurred, right? And we know that the victim was tortured, but we don't know exactly who did the torture because we don't have video of it, or our victim was blindfolded. So the victim was not aware of who was torturing him or her. Now, when this case is reviewed, initially there may be a plea bargain offered. Now, you may not want to go, if you're the defendant, you may not want to go and face a jury. And the jury is going to hear these facts of how you abducted this person, how you held them captive, you kidnapped them, then you tortured them, you abused them, you harmed them. So this defendant is thinking, well, it may be better for me if I take this deal Now, the deal could come in a way of, like I said, dropping charges, reducing the charges, recommending a lighter sentence, different things like that. Um, but because, say, you arrested all the actors, say it's four actors involved, but you don't know the actual level of each actor's involvement, you may consider giving a plea bargain because you really don't have sufficient evidence to show all of the crimes for each person individually. But guess what? Say they all got a plea bargain and the cases are resolved, they're in jail. But say some time passes by and you discover new evidence. Now you have evidence that the torture was videotaped. So not only did all of the actors get involved, it was more heinous. So maybe there was people that got a much lighter sentence because you didn't think they were involved and you couldn't prove it, you couldn't demonstrate it, you didn't have enough evidence. But now this videotape has been discovered, and you watch it, and now you see people that got this lighter sentence, lesser charges, they were actually involved in the torture. They were an actor, they were there, and they also participated. So sometimes things like this happen, and people are kind of upset because they feel, well, what is the community's best interest? Sometimes I believe that we don't always know everything, and this happens, and it can be very hard for the victim, for their family, and also for the community. But for the most part, the plea bargaining deals that happen where a case never sees the courtroom, never goes to trial, this is a way that about 98% of cases get resolved this way. And sometimes things fall through the cracks, mistakes are made, and just not always having all of the information, all of potential evidence, right? So we definitely want to think about that. Um, Sometimes the judges, they can kind of work to be the end result. So if the judge knows that there's a plea bargain and there's time for sentencing, say for example, um, there was a first degree murder charge, and then there's now a plea bargain for a second degree murder charge because for whatever reason there's not enough evidence, or the victim is traumatized, the victim does not want to come to court and face her accuser. She may be he or she may be um, very distraught. um, they may just need so many services after, well, it can't be a murder charge. It has to be, let's do a S assault. A S assault in the first degree because the victim wouldn't be coming to court. But for whatever reason, the victim cannot come to court because of what has happened to him or her. And the judge may be accepting this plea bargain because this plea bargain may be putting on the record the facts, what happened that the assailant did to the victim. Now, the judge will do the sentencing, and instead of giving maybe what is recommended, say there's a 10 to 20, a range, a 10 to 20 year or 10 to 15-year range, the judge may not be um, as quick to just, this is a recommendation by the prosecutor, but the judge knows the facts, right? So the judge may accept the plea bargain but still not give a light sentence. He may push for that 12, 13 years versus the 10 years because he knows what is on the record, what has happened to the victim. So in those cases, does it always benefit the defendant to plead guilty, right? To plead guilty even to a lesser charge if in the end he's still going to get a harsher sentence by the judge. So you have to kind of weigh that out. The defendant has to weigh that out. Does the defendant want to go to trial? Um, and possibly get 15 years, right? Or possibly get the higher charge where that can be 20 years to life, right? He has to weigh that out. That's why he has counsel. Um, and he has to consider that. Um, uh, do you want to take a risk? Because if you go to trial, they're going to recommend the higher end, the higher end. If it's 20 years, they're going to recommend 20 years. If you make them fight in, fight in trial, and not take that plea bargain, because now they have to really work, they have to prepare their witnesses. Sometimes you have poor witnesses, witnesses that aren't able to speak in front of people, witnesses that may have fear, witnesses that may know the defendant and may not want to testify against the defendant. You have all kind of circumstances. It's very, very challenging to make a balance of all of what happens, right? Um, so the plea bargain system weeds out about 98% of the cases. So most of the time, you're never going to trial. You have certain cases like this Carlee Russell case that's going to go to trial. I guess there's hope that one person will somehow say she's not guilty. I don't know how, but okay. Um, but she's gonna appeal it. So we get all kind of reasons why majority of the people take the plea bargain versus go to trial. Um, I think that uh, you have to, you also have to consider some of the witnesses may also not want to testify because of what they're involved in. So, for example, you can have a witness, and the witness was doing something like um, prostitution, possibly drug dealing. So, they don't want to get on that stand and say that I was doing this illegal behavior while I'm also a witness. And then it may go to their credibility. And then they're also going to be cross examined by the defense, and they're probably going to be attacked. And they're probably going to have it so that they don't seem as reliable, as trustworthy, as honest because of their activity. So sometimes, if they have some criminal activity going on, you might not want to use them as a witness because of those reasons I'm describing. So sometimes you just run into problems um, where you can't really use that person as a witness, or you're not able to. They may not even be available. Um, sometimes you just have all kind of problems. You may have problems with how evidence was collected. Um, maybe evidence wasn't handled properly. Maybe evidence wasn't seized properly. Maybe evidence wasn't stored properly. And how can you put that person on as a witness, right? So instead of doing that and revealing that part of your hand, you go and you try to do a plea bargain. You don't even reveal some of the things that's behind the scenes in your evidence or your witnesses, things like that. Maybe the unavailability of witnesses, or you can't even use a person as a witness. You don't reveal that. You try to resolve the case as a prosecutor through the means of the plea bargain, because you have to realize that it can be so true that you know something happened and you know the person did it, but that doesn't matter. The only thing that matters is what you can prove, what evidence is allowed to be introduced. So sometimes you can know something, you can know that the person is guilty, but can you prove it? Do you have the support of evidence to show that, to demonstrate that? And is that evidence going to even be allowed into the courtroom for consideration? Even witnesses, again, you can have all kind of issues with witnesses. Are they reliable? Are they believable? What is their background? Would they be uh, believed by a jury? How is a jury going to perceive them and what they're saying, or their occupation, or were they doing some criminal activity, or is this a situation where instead of them being charged for a crime, you're kind of exchanging that for their testimony, because that can get kind of murky. So you have all kind of situations why the plea bargain is happening, and sometimes the defendant is not even aware of that and doesn't know why things are happening. Maybe the case would have even been dismissed for just lack of evidence, a lack of sufficient evidence, or the inability to have witnesses that can prove the case, the charges, right? So I just wanted to kind of give you that background. Now let's go over this one article, and then I think we got the idea of the plea bargain under wraps. So we're going to go to npr.org. The title is "The Vast Majority of Criminal Cases End in Plea Bargains, a New Report Finds." This article is by Carrie Johnson and it's dated February 22nd, 2023. In any given year, 98% of criminal cases in the federal courts ends with a plea bargain, a practice that prizes efficiency over fairness and innocence, according to a new report from the American Bar Association. A task force that includes prosecutors, judges, defense attorneys, and academics cited substantial evidence that innocent people are coerced into guilty pleas because of the power prosecutors hold over them, including the prospect of decades long mandatory minimum sentences. Trials have become rare legal artifacts in most U.S. jurisdictions and even non existent in others. The ABA Plea Bargain Task Force wrote in a report released on Wednesday. Aside from the paltry number of trials in the federal system, states including Pennsylvania, Texas, and New York have trial rates of less than 3%. In Santa Cruz County, Arizona, there were no trials from 2010 to 2012, the report said. Wow, that's a long time not to have a trial, right? The prevalence of plea bargaining exploded in the last several decades as a way to save money and time and to promote more certainty in outcomes. But the practice comes with a very high cost, said Lucien Durbin, a professor at Belmont University College of Law in Nashville. Pleas can allow police and government misconduct to go unchecked because mistakes and misbehavior often only emerge after defense attorneys gain access to witness interviews and other materials with which they can test the strength of a government case before trial. The deals also, ex- I'm going to pronounce this wrong, exacerbate sorry, racial inequality, with black defendants more often subject to prosecutors' stacking of multiple charges in drug and gun cases. Altogether, defendants face stiffer punishments for going to trial, known as a trial penalty, that can add 7 to 9 years or more to their sentence. Now, I know about that trial penalty. As I said, if you make the prosecutor go to trial, they're going to pursue the max. If there are sentencing guidelines, they want the max for you because you're forcing them to prove this case. And it's a lot of work. It's a lot of work behind the scenes to prepare for a case and discovery. Excuse me. But most stark in the report is research that cites innocent defendants who agree to falsely plead guilty, sometimes on the advice of their own lawyers. An Innocence Project database of exonerations include dozens of people who falsely pleaded guilty. This isn't just having an effect on those individuals, said Durbin, who co chaired the task force. It's having an effect on the entire community and the safety of the entire community. Overhauling the justice system will be no easy task, since it could require changes to laws and ethics rules in many U.S. states. It's past time to start that work, said Durbin, who recently created the Plea Bargaining Institute to generate and share research. The ABA task force makes 14 recommendations, including the need to collect and analyze data on plea bargains, the need to give defendants access to discovery materials before they enter a plea, and the need to eliminate bail requirements or pre-trial detention when they're used to coerce someone into pleading guilty. The report also presses prosecutors and judges not to demand or accept plea deals where defendants waive essential legal rights, such as the right to appeal and receive exculpatory information and the right to make future claims for release for reasons of terminal illness. So, I just wanted to talk a little bit about plea bargaining today because I caught at the end when I thought about it this morning. Like they offered her a plea bargain, like really they offered Carlethia Russell a, a plea bargain, and she said no. And she's not innocent. She is not innocent of the two charges. She clearly has said that this was not true, the things that she said. So human behavior, right? You cannot put your finger on it. You can't really figure out what someone is going to do or what they're thinking. I believe it's because of the jail times, like the attorney Emery said. She doesn't want to do the jail time, so they're gonna try and appeal it and see what happens. You usually see that more so in cases where people are innocent, um, but you know, Um, I guess she's thinking that she may get a better result with the appeal versus just wrapping it up, finishing things, and kind of moving on. Um, she probably would have been out by Christmas if she just went on ahead and, you know, pled guilty and did the days. So that's all I got. I hope you learned something about plea bargains. They're very, very, very common. Most cases, like I said, 98 out of 100 is going to take a plea. Now, is that rightfully so? Is that with all the knowledge? Um, is that with the attorneys kind of recommending or pushing that? Every case is really separate. I know the prosecutor, they're using that as a tool. It gets cases off their desk. They can focus on um, more cases, more substantial cases. Maybe there's a question of the law, or um, there is a victim in that crime versus some other cases that are not, that are more straightforward. You get a lot of DUIs, you get a lot of small property cases, theft, things like that, that maybe are not as significant, where you focus more of your energy on victim crimes, especially in bigger cities. So that's what I wanted to bring today is the plea bargain that Mrs. Russell rejected, and also just giving you some background about the plea bargain. It is commonly used. It is a tool. I think some defendants may benefit from it also with the dropping of charges, a less sentence. Um, they also get a benefit, but sometimes I think they don't have the information about how a case may not be as strong, or there may be some issues with the evidence or a witness, things like that. The prosecutor isn't going to reveal his or her hand. They're going to offer that plea bargain, and most people they take it because the greater risk is that they're going to go to trial and get a harsher sentence, and also, it may be facts in that case that they don't want revealed to the public. Even though they have to put things on the record, the trial could really display some factual things about them or their behavior, things that they've done or thought, and sometimes that is hard. And some defendants don't want that. They don't want their family embarrassed. They rather go in front of a judge and take 1 minute and say, um, for example, I went up to the school, I saw this young child, I snatched him, I abducted him, I kidnapped him, I did take him back to my home, I did abuse him, and I unalived them. You can do that in about 30 seconds versus a trial that could go on for weeks. It could be in the media. They may even try to get different witnesses to come forward to really describe the type of person you are, your character, describe the family that you grew up with. Like most people that are guilty, they do not want that information out about them because say if they go to court, right, and they're convicted, and they go or they plead and get a shorter sentence, they can come right back into the same community. But if people know all the horrible things about them and the facts of the case more in detail, how many people are showing up at their sentencing? How many people are showing up for all these hearings? Maybe not many, right? The victim's family probably will be there. They may ask their family not to even come, not to show up because of maybe they feel embarrassed or they don't want their family to cross the victim's family, things like that. So they don't want those details out. So for all kind of reasons, uh, defendants accept the plea bargain. It's very, very common. I don't think they're going to be able to reduce that by too much. Um, because there has to be a benefit, right? There has to be a benefit for the defendant. If you are not guilty, then you should pursue and take on all your rights to go to trial if you choose to. But I don't think you can be forced to, especially if you feel the outcome on the other side might be better taking the plea bargain because you may have charges dropped, you may have reduced time, um, you may not even have to address certain things in those charges. So people take the plea bargain for all kind of reasons, and I believe there's a benefit both to the prosecutor and the defense. That one is really not better than any other because if you're innocent, why say you're guilty? Why are you agreeing to things that you didn't do, and you still have to stand in front of the judge and give an adequate statement to demonstrate why you're guilty, what you did. I mean, are you going to just create a whole lie and you know? So for the most part, the system is a working machine, and there's a lot of cases. So this is one way that the cases are removed out of the system, closed out, resolved. Also, dismissal of cases, right? Maybe the prosecutor feels there's a lack of evidence, a lack of witnesses, maybe not enough information, and just decides to dismiss the case. Um, so just different things like that. So thanks for checking out this video. Check out some of my other videos. Stay safe, stay smart, stay savvy. Enjoy your day, okay? Have a wonderful day. Thanks for checking out this video. Bye, friends. Bye, everybody.